Now the investigation is in front of these rabid Democrats on Capitol Hill, Gerald Nadler, Adam Schiff, Maxine Waters, Schumer over there in the Senate. I mean, you name it. These people are out to kill, figuratively speaking, let's hope not literally, the President of the United States, Donald Trump, and to subjugate the will of the American people. We're headed into an impeachment. But all politics aside, we didn't have a Justice Department until July 1st, 1870. The American people need to do it for themselves. And this concept of the citizens' grand jury, and interestingly enough, there are certain states that allow for citizens' grand juries in different settings, different procedures. But we are entitled to ourselves meet. We have that legal right. The great Justice Antonin Scalia, may his soul rest in peace, in 1992 wrote a majority opinion in a case styled United States versus Williams, where he held that the grand jury does not belong to the three branches of government, neither the legislative branch, the judicial branch, or the executive branch. It belongs to the American people. And that was a case that involved the defendant challenging the level of proof, and we're going to get into that at a grand jury. This defendant said, well, you didn't really have evidence to indict me because you used hearsay and you used other information. And Justice Scalia, in that context, wrote that the grand jury does not technically go by the same rules that you would go in terms of convicting someone in a court of law, which is beyond a reasonable doubt. It's probable cause. And that simply is a reasonable suspicion. I'm going to read you these jury instructions in a few minutes. That doesn't mean that you deliberate and make a decision based on politics or based on your predilections. And I ask all of you who came into this room today to leave your politics at the door, to make an objective decision based upon the standard for indicting. But we're not even bound by the rules of criminal procedure. We're not bound by what the Justice Department does. We're bound by common sense and the law of God. We're bound by moral law, human law. But I am going to use, as you'll see, federal law as a guidepost in terms of what we're doing, because we want to stay as close to that as we can with recognized statutes and common law that we can use to deliberate here. Now, after I finish this introduction, I want you to nominate a jury foreman who will either sign an indictment or decide not to sign an indictment on your behalf if you issue a true bill of indictment at the end of this proceeding, and to do so, as I said, neutrally and equally. Now, if you want to know the truth about our justice system, and we were talking about the judges before, the fact that you may have political views or may be a member of this political party or another or voted for somebody is totally irrelevant. The fact that you're white, black, green, yellow, whatever religion you may be is irrelevant. In fact, the Supreme Court has said that you can't strike jurors from a jury simply because of their race or religion, or creed. So you're entitled to be here, whatever you may think or whoever you may vote for, as much as any federal judge, because those judges are all politicians, and that's how they got their job. So this is what we're going to do today, and this is our first session. We're going to meet periodically. Grand juries don't have to meet once. They meet more than once. I want to keep it very focused today, and the indictment which I am seeking as your special prosecutor is against Robert Mueller. Of course, he is someone who has conducted what I personally believe is an unwarranted investigation. He has violated people's constitutional rights. He has violated the rule of law. He has violated our Constitution. And although he has various prosecutors working beneath him, he's the one who's ultimately responsible. He's the one that gave the orders. He's the one that assembled the team. But we're going to limit the focus today to someone who I represented successfully and kept him from being indicted, Dr. Jerome Corsi, and he's going to come on and he's going to provide information to you to consider the indictment. And just as a preview, he's going to testify about him being a target of one of Mueller's investigations, and that he was asked to lie to implicate the president. To be listened to as far as Dr. Corsi, he was asked to lie. If he wasn't going to lie under oath, he would be indicted. And you'll hear Dr. Corsi's testimony. The testimony will show that he could not lie in front of his creator, and he would not get a sweetheart plea deal, which they offered him to plead guilty to one perjury count if he would lie against the president about his contacts with Roger Stone and WikiLeaks. And the reason that he was not indicted, I believe, is because Dr. Corsi pushed back. He actually brought a lawsuit against Mueller, which I brought for him, and filed complaints with the Office of Professional Responsibility and Inspector General at the Justice Department. Well, the Justice Department is unlikely to do anything because they protect their own. Mueller is part of the Justice Department. It did serve as a warning to Mueller not to push too hard. And the significant difference between Dr. Corsi and Roger Stone, and I'm going by Roger Stone's own words in emails, is that Jerry Corsi testified truthfully and Roger Stone did not. And Dr. Corsi did not threaten to kill a material witness and his dog, and that's why Stone's been indicted and Corsi has not. So this is what we're dealing with here today, and I want you to consider what we're putting forth very, very seriously. And at the end of this introductory session, and I'm going to read you the instructions of how you deliberate right now, and I put them in writing in front of you, and they'll be part of this proceeding. You'll be able to see how to dissect the information and documentation that we're going to put forth. Now, Jason Goodman is also going to testify because he assisted me in a Freedom of Information Act lawsuit where we got documents showing that Robert Mueller and his staff were leaking grand jury information. That's one of the allegations with regard to Dr. Jerome Corsi. They leaked information to try to harm him and to smear him and to bludgeon him into accepting a plea agreement. And they've done that with a number of other witnesses. But today we're just going to focus on Robert Mueller. We'll get to his prosecutors and subsequent grand juries. We'll get to people like James Comey, like Andrew McCabe, like the Lovebirds, Lisa Page and Peter Strzok, and of course Bruce Orr, and let's not forget about John Brennan and James Clapper, Obama's intelligence czars who violated the constitutional rights of hundreds of millions of Americans with illegal surveillance. And of course, at the end of the day, we have President Obama and Hillary Clinton, who really were they were like the evil version of the Wizard of Oz that were behind the curtain orchestrating this, in my view. I'm not telling you what to think. Now, let me read to you the jury instructions. Again, impartiality is of crucial importance. I'm a prosecutor. I don't have to be impartial. That's not my role. But it is your role to be impartial. These are the jury instructions. Number one, members of the jury, now it is time for you to be instructed about the law you must follow in deciding whether the criminal charges are proper. State or federal law does not bind the citizens' grand jury. Ethics, morality, and justice bind it. Number two, I will start by explaining your duties and the general rules that apply in every criminal case. Number three, then I will explain the elements of the crimes that Defendant Mueller, by and through his prosecutorial and other staff he hired and supervised, including but not limited to his press secretary, Peter Carr, is accused of committing. You may think of the elements, quote unquote, of the crimes as the essential ingredients, as important parts of the proof of the crimes. Defendant Mueller hired several attorneys to work under him and serve as prosecutors, including Jeannie Rhee, Andrew Goldstein, Aaron Zelinsky, and L. Rush Atkinson. Defendant Mueller, as their supervisor and employer, is to be held liable and responsible, as the proof that will be put forth before you will show, for the wrongful acts of his employees and agents, pursuant to the long-standing legal doctrine of respondeat superior, as the coercion and intimidation occurred within the scope of his prosecutors employment, and activities. 4, then I will explain some rules that you must use in evaluating particular testimony and proof. 5, and last, I will explain the rules that you must follow during your deliberations concerning whether the criminal charges are proper. 6, please listen very carefully to everything I say and the witnesses say, as well as documentary evidence. Your duties, jurors' duties. 1, you have 2 main duties as jurors. The first one is to decide what the facts are from the proof that you saw and heard today. Deciding what the facts are is your job, not mine, and nothing I have said or done during this proceeding was meant to influence your decision about the facts in any way. 2, your second job is to take the law that I give you, apply it to the facts, and decide if the citizen's grand jury prosecutor, that's me, has shown that there is probable cause to bring the criminal charges against defendant Mueller. It is my job to instruct you about the law, and you are bound by the oath you took at the beginning of this proceeding to follow the instructions that I give you, even if you personally disagree with one or more of them. All of the instructions are important, and you should consider them together as a whole. Do your jobs fairly. Do not let any bias, sympathy, or prejudice that you may feel for or against either side influence your decision in any way. Do you all subscribe to this oath? You can tell me by a voice vote.
Yes.
Okay. Burden of proof, probable cause. 1, the grand jury sits not to determine guilt or innocence. That's important, but to assess whether there is adequate basis for bringing a criminal charge. It is the grand jury's function not to inquire upon what foundation the charge may be denied or otherwise to try the suspect's defenses, but to examine upon what foundation the charge is made by the prosecutor. That's the United States versus Williams case, 504 U.S. 36, 51 to 52, 1992. That's the Scalia decision I was talking to you about. The citizen's grand jury prosecutor does not have to present substantial exculpatory evidence, like I would if this case goes to trial, if I have it. The grand jury can investigate merely on suspicion that the law is being violated, or even because the grand jury wants assurance that the law is not being violated. These are the words of Justice Antonin Scalia. That's a quotation. The theory is that the indicted individual or entity will have an opportunity at trial to disprove his guilt. Right now, we just need probable cause to go to a trial, and that will happen after this. We will later set up a citizen's trial. We will seek to convict if you issue a true bill of indictment. We will then ask a presiding judge that will come over this, a retired judge or someone of equal qualification, to sentence, and then we will seek to mete out the sentences if there are any peacefully and legally. 2, as you know, defendant Mueller has not pleaded to the crimes charged in the indictment. The indictment is not any proof at all of guilt. It is just the formal way that the citizen's grand jury prosecutor tells the defendant what crimes he is accused of committing. It does not even raise any suspicion of guilt because there will be a trial. Robert Mueller, if he's indicted, will have a chance to make his defense. He'll be invited to appear and to offer his defense with any lawyer he wishes to hire or pro se by himself. 3, no defendant has any obligation to present any proof at all or to prove to you in any way that he is innocent. It is up to the citizen's grand jury prosecutor to show that the indictment is proper and that there is probable cause for bringing such criminal charges. You must find that no criminal charges should be brought against defendant Mueller if the citizen's grand jury prosecutor has not shown you that there is sufficient reason upon which the facts to believe that these crimes have been committed. The citizen's grand jury prosecutor must show every element, that is, every important part of the crimes charged, only by the low threshold of probable cause. Showing probable cause means a sufficient reason based upon facts to believe a crime has been committed or that certain property is connected with a crime. Probable cause is often subjective, but must exist prior to arrest, search, or seizure. 6, if you are convinced that the citizen's grand jury prosecutor, through the proof, has shown by probable cause that the indictment is proper, then you must vote to secure the indictment. If you are not convinced by probable cause, then you must vote not to initiate the charges against defendant Mueller. First, make your decision based only on the proof that you saw and heard. Do not let rumors, suspicions, or anything else that you may have seen or heard outside of this proceeding influence your decision in any way. 2, citizens' grand juries are not constrained to consider only evidence which would be admissible in a citizen's court or even a federal or state court. Even hearsay testimony and documentary proof may be considered and weighed. That's United States versus Williams again. 3, the citizen's grand jury prosecutor's statements and arguments are not proof. What I say is not proof. His questions and objections are not proof. The indictment is not proof. Comments and questions are not proof. Do not speculate about what some witness may have said or what some exhibit may have shown. Such things are not proof. You are bound by your oath not to let them influence your decision in any way. 4, make your decision based only on the proof put forth by the citizen's grand jury prosecutor as I have defined it and nothing else. Next, consideration of proof. You should use your common sense in weighing the proof. Consider it in the light of your everyday experience with people and events, and give it whatever weight you believe it deserves. If your experience tells you that certain proof reasonably leads to a conclusion, you are free to reach that conclusion. Direct and circumstantial proof. First, we have already discussed the terms direct proof and circumstantial proof for the purposes of the indictment. Direct proof is simply proof that the testimony of any eyewitness, if you believe it, directly proves a fact. If a witness testified that he saw something walking across a field and you believed him, that would be direct proof that such a thing had happened. Circumstantial proof is simply a collection of circumstances that indirectly proves a fact. If a witness said that he saw fresh footprints in newly fallen snow, that would be circumstantial proof from which you could conclude that someone had recently been walking there. Legally, there is no difference between direct and circumstantial proof. The law does not say that one is necessary or better proof than the other. You should consider all the proof, both direct and circumstantial, and give it whatever weight you believe it deserves. Credibility of witnesses. Part of your job as jurors is to decide how believable each witness was. This is your job, not mine. It is up to you to decide if a witness' testimony was believable and how much weight you think it deserves. You are free to believe everything that a witness said, or only part of it, or you can believe none of it at all, even if the witness had not been contradicted. But you should, of course, act reasonably and carefully in making these decisions. Now, let me suggest some things for you to consider in evaluating each witness's testimony. First, ask yourself if the witness was able to clearly see or hear the events. Sometimes, even an honest witness may not have been able to hear or see what was happening and may make a mistake. Ask yourself how good the witness's memory seemed to be. Did the witness seem able to accurately remember what happened? Ask yourself if there was anything else that may have interfered with the witness's ability to perceive or remember the events. Ask yourself how the witness looked and acted while testifying. Did the witness seem to be honestly trying to tell you what happened? Or did the witness seem to be evasive, confused, or even lying with his or her eyes shifting in every direction? It's just one example. Ask yourself if the witness had any relationship to either side of the case or anything to gain or lose that might influence the witness's testimony. Ask yourself if the witness had any bias or prejudice or reason for testifying that might cause the witness to lie or to slant testimony in favor of one side or the other. Ask yourself if the witness testified inconsistently or if the witness said or did anything off the stand that is not consistent with what the witness said while testifying. If you think that the witness was inconsistent, ask yourself if this makes the witness testimony less believable. Sometimes it may, other times it may not. For example, you might consider whether the inconsistency was understandable or explainable. You might also ask yourself if it seemed like an insignificant or common mistake, or if it seemed to indicate a deliberate attempt to mislead. Finally, ask yourself how believable the witness's testimony was in light of all the other proof, Was the witness's testimony supported, or was it contradicted by other proof that you found believable? If you think that a witness's testimony was contradicted by other proof, keep in mind that people sometimes do forget things, and that even two honest people who witness the same events may not describe it exactly the same way. These are only some of the things that you may consider in deciding how believable or reliable a witness is. You may also consider other things that you think shed light on the witness's believability. This is what I was saying before. Use your common sense and your everyday experience in dealing with other people, and then decide what testimony you believe and how much weight, that is, how much significance you think it deserves. One more point about the witnesses. Sometimes jurors wonder if the number of witnesses who testified on a particular point or on one side or the other makes any difference. It does not. Do not make any decisions based on the number of witnesses who testified. What is more important is how believable the witnesses or witnesses were and are, and how much weight you think their testimony deserves. Concentrate on that, not the numbers. Now, the elements of the offense. This is an introduction of what we're seeking to charge Special Counsel Robert Mueller with. First, that concludes my part, the part of my instructions in explaining your duties and general rules that apply in every criminal indictment. In a moment, I will explain the significant elements of the crimes that the defendant is accused of committing. So I want you to keep this in mind for subsequent grand juries too, and I'm giving you these instructions in writing. You can take them home with you. Okay, so when we reconvene, you'll have them with you, and I will need to read this again, because this grand jury is going to be continuing. It's not going to end today. This is only considering the indictment of Robert Mueller. Element number 2, your job is limited in deciding whether Citizens Grand Jury prosecutor has shown by probable cause that the criminal charges should be brought against defendant Mueller. Defendant Mueller hired, supervised, and directed attorneys Jeannie S. Rhee, Andrew D. Goldstein, Andrew S. J. Zielinski, and L. Rush Atkinson. They were all involved in the threats, as I'm going to set them forth through testimony of Jerome Corsi, to have him lie and to implicate the president in crimes. Through the course of the alleged Russian investigation, these prosecutors, under the supervision of and at the direction of defendant Mueller, dealt directly with Dr. Corsi. Also keep in mind that whether anyone else should be prosecuted and convicted for this crime is not a proper matter for you to consider at this time. The possible guilt of others is no defense to a criminal charge. Your job is to decide if the Citizens Grand Jury prosecutor has shown by probable cause that the criminal charges against defendant Mueller have merit. Do not let the possible guilt of others influence your decision in any way. Count 1 of the indictment that I'll be requesting that you issue. Under Federal Rule of Criminal Procedure 6, small e, close paren, 2, close paren. Count 1 of the indictment charges defendant Mueller with violating Federal Rule of Criminal Procedure 6E2, which is a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find that Citizens Grand Jury prosecutors showed by probable cause that each of the following 3 elements. Number 1, defendant Mueller worked with an attorney for the Office of Special Counsel, which is a government office. 2, that he disclosed a matter concerning the grand jury. 3, to a person unauthorized to receive the information. You must find that the Citizens Grand Jury prosecutor has shown by probable cause all 3 of these things in order to find that the criminal charge can be brought against defendant Mueller. Count 2, 18 U.S. Code Section 401, paren 2, close paren. That's the law that we're going under for count 2. Count 2 of the indictment charges defendant Mueller with the unauthorized disclosure of grand jury information, which is contempt of court and a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find that the Citizens Grand Jury prosecutor showed by probable cause each of the following 4 elements. 1, defendant Mueller was an officer of the Court of the United States. 2, that he misbehaved. 3, that the misbehavior was in defendant Mueller's official transactions. 4, and that the misbehavior was committed with criminal intent. Criminal intent is defined as a volitional act done by one who knows or should reasonably be aware that his conduct is wrongful. You must find that the citizen's grand jury prosecutor has shown by probable cause all four of these things in order to find that the criminal charges can be brought against defendant Mueller. Count 3, 18 U.S. Code section 641, federal law. Count 3 of the indictment charges defendant Mueller with theft of intangible government property, which is violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find that the citizen's grand jury prosecutor showed by probable cause each of the four elements. The property described belonged to the United States. This would be the grand jury information. Defendant Mueller knowingly converted the property to his own use or someone else's use. Defendant Mueller knowingly and willfully intended to deprive the owner of the use or benefit of the property, and the property had a value greater than $1,000. You must find that the citizen's grand jury prosecutor has shown by probable cause all four of these things in order to find that these criminal charges can be brought against defendant Mueller. Count 4, 18 U.S.C., that's U.S. Code, section 1512, paren small b, close paren, paren 1, close paren, and 2, that's paren 2, close paren. Count 4 of the indictment charges defendant Mueller with tampering with a witness, which is a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find the citizen's grand jury prosecutor showed by probable cause each of the following four elements. 1, that defendant Mueller knowingly used intimidation or threatened or corruptly persuaded Dr. Corsi, who's going to appear as a witness, or attempted to do so, or engaged in misleading conduct towards Dr. Corsi. And 2, that defendant Mueller acted with intent to influence the testimony of Dr. Corsi in the grand jury proceeding. 3, that defendant Mueller knew or should have known that the grand jury proceeding was pending or likely to be instituted. And 4, that the grand jury proceeding was a federal proceeding. Incidentally, this is what Roger Stone, the crime he allegedly committed by trying to allegedly threaten a witness and to kill a witness and his dog. Okay, so it's ironic that I'm seeking an indictment for Mueller against the same thing that he indicted Roger Stone for. You must find that the citizen's grand jury prosecutor has shown by probable cause all four of these things in order to find that the criminal charges can be brought against defendant Mueller. Count 5, 18 United States Code, section 1513. Count 5 of the indictment charges Mueller with retaliating against or tampering with against a witness. This is a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find that the citizen's grand jury prosecutor showed by probable cause each of the four elements. That defendant Mueller knowingly engaged in conduct. 2, that defendant Mueller's conduct caused damage to Dr. Corsi's livelihood. That defendant Mueller acted with specific intent to retaliate against Dr. Corsi for not providing false testimony, and that the grand jury proceeding was a federal proceeding. You must find that the citizen's grand jury prosecutor has shown by probable cause all four of these things in order to find that the criminal charges can be brought against defendant Mueller. Count 6, violation of 18 U.S. Code, section 1505. Count 6 of the indictment charges defendant Mueller with obstructing justice before a department, agency, or Congress, which is a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find that the citizen's grand jury prosecutor showed by probable cause each of the following four elements: that there was a proceeding being conducted by any department or agency of the United States. 2, that defendant Mueller knew of the pending proceeding. 3, that defendant Mueller endeavored to influence, obstruct, or impede the proceeding. And 4, that defendant Mueller did so corruptly or by threats or force or by any threatening letter or communication. Corruptly means to act knowingly and dishonestly with specific intent to subvert or undermine the integrity of a proceeding. Corruptly means nothing more than an intent to obstruct the proceeding. A corrupt intent may be defined as the intent to obtain an improper advantage for oneself or someone else inconsistent with official duty and the rights of others. You must find that the citizen's grand jury prosecutor has shown by probable cause all four of these things in order to find that the criminal charges can be brought against defendant Mueller. Count 7, violation of 18 United States Code section 1622. Count 7 of the indictment charges defendant Mueller with conspiracy to suborn perjury, which is a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find that the citizen's grand jury prosecutor showed by probable cause each of the following three elements. 1, defendant Mueller voluntarily and intentionally persuaded Dr. Corsi to commit perjury. 2, defendant Mueller did so with the intent that Dr. Corsi would deceive the grand jury. 3, Dr. Corsi would have committed perjury in that he would have testified under oath that the testimony would have been false at the time he testified falsely, and that he knew the testimony was false, and that Dr. Corsi gave such testimony voluntarily and intentionally. Conspiracy to suborn perjury may be prosecuted irrespective of whether actual perjury has been committed. You must find that the citizen's grand jury prosecutor has shown by probable cause all three of these things in order to find that the criminal charges be brought against defendant Mueller. Count 8, 18 United States Code 1001. Count 8 of the indictment charges defendant Mueller with attempting to elicit and provide false statements to the grand jury, which is a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you should find that the citizen's grand jury prosecutor showed by probable cause each of the following 5 elements. 1, defendant Mueller attempted to force Dr. Corsi to make a false statement and attempted to make use of the statement. 2, the statement would have been false. 3, the falsity concerned a material matter. 4, defendant Mueller acted willfully, knowing that the statement would be false. And 5, the false statement was attempted to be used or for a matter within the jurisdiction of a department or agency of the United States. You must find that the citizen's grand jury prosecutor has shown by probable cause all 5 of these things in order to find that the criminal charges can be brought against defendant Mueller. Count 9, 18 U.S.C. 2381. Count 9 of the indictment charges defendant Mueller with treason, which is a violation of federal law. In order to find that the indictment should be brought against defendant Mueller, you must find that the citizen's grand jury prosecutor showed by probable cause each of the following 4 elements. 1, that defendant Mueller owed an allegiance to the United States. 2, that defendant Mueller did not try to wage war against the United States or did give aid and comfort to the enemies of the United States. And 3, that 2 witnesses testified to the same overt act of waging war or giving aid and comfort, and defendant Mueller acted with a purpose to aid the crime, the enemy. You must decide that the citizen's grand jury prosecutor has shown by probable cause all 4 of these things in order to find that the criminal charges can be brought against defendant Mueller. Next, experiments, research, and investigation. 1, remember that you must make your decision based only on the proof that you saw and heard here. This means that you must not try to gather any information about the case on your own while you are deliberating. 2, for example, do not conduct any experiments inside or outside of the jury room. Do not bring any books like a dictionary or anything else that will help you with the deliberations. Do not conduct any independent research, reading, or investigation about the case, and do not visit any of the places that were mentioned during this proceeding. Finally, make your decision based only on the proof that you saw or heard here. The duty to deliberate. Now that all the proof and arguments are complete, you are free to talk about the case. In fact, it's your duty to talk with each other about the proof and to make every reasonable effort you can to reach unanimous agreement. Talk with each other, listen carefully and respectfully to each other's views, and keep an open mind as you listen to what your fellow jurors have to say. Try your best to work out your differences. Do not hesitate to change your mind if you are convinced that other jurors are right and you are wrong. But do not ever change your mind just because other jurors see things differently, or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. No one will be allowed to hear your discussions, and no record will be made of what you say. So you should all feel free to speak your minds. 4, listen carefully to what everyone else has to say, and then decide for yourself if the citizen's grand jury prosecutor has shown there is probable cause to bring criminal charges against defendant Mueller. Citizen's grand jury prosecutor has no opinion. Let me finish up by repeating something that I said to you earlier. Nothing that I have said or done during this proceeding was meant to influence your decision in any way. You decide for yourselves if the citizen's grand jury prosecutor has shown that there's probable cause to bring the criminal charges against defendant Mueller. Prosecutors, plaintiffs' lawyers, or whatever, we have our own opinions. We have our views. A long time in my past, a senator from Florida, which was my home state, asked me if I wanted to be a judge. Connie Mack. I said, no, I don't want to be a judge. I'm an advocate. I don't want to sit in that position. This is my role. This is who I am. So you are not to take my opinions into account. You're to just listen to the proof and make your decision. Now, when we convene after the proof is provided to you, first there will be Dr. Jerome Corsi, then there will be Mr. Goodman, who analyzed the documentary evidence that we obtained through FOIA, Freedom of Information Act, over the grand jury leaks. We will convene, and you will go to a room. You can stay in this room, and I'll leave, actually. We're in a low budget, okay? And you will designate a foreman, someone who will sign indictment if you issue a true bill of indictment, and someone who can come back and then ask me questions while you're deliberating. And you, of course, can ask me questions now about the instructions that I just read to you. And please keep the written copy of the instructions so you can refer to them, when you are deliberating. So what I just did is very similar to what the judge would do, but with a higher standard of proof to a petit jury in a criminal trial. But it's tailored for a grand jury and a showing of probable cause. So feel free to ask me any questions now, and then we'll see if we can hook Dr. Corsi up.
As a targeted individual, wherever I go, places are bugged. How do we know this place is not bugged by the other side?
Well, you don't know that. But in today's world, I think, this is my own opinion, you can't expect privacy in anything that you do. So we just have to stand up for yourself and assert your legal rights. I can assure you that every American in this country is subject to surveillance by the National Security Agency, the CIA, and the FBI. All of our telephone, email records, and everything else are accumulated. So you should be careful what you say on these media. But we're not doing anything illegal or anything that's wrong, and it cannot be held against you. And if it is, you let me know.
Would you define the word suborn, please?
To further perjury, I would just say simply further it, okay?
Further
To suggest it, to further it, to facilitate it.
Another question? Sorry.
You're going.
Another question is just in terms of process. So they're laid out 1, 2, 3, 4, 1, 2, 3, 1, 2, 3, 4, 5. Is there any restriction or requirement or suggested procedural approach, meaning that some appeared to me on first reading that they might be easily determined among ourselves? Is that something that we might go after piece 1 of section 1, piece 4 of section 5, piece 3 of section 2, and say these all have similar characteristics? Is this something?
Yes, the evidence will overlap.
Okay.
In fact, with regard to the witness tampering, obstruction of justice, it all overlaps substantially. So you can be charged on multiple different crimes for doing the same thing with the same set of facts.
So if we have found in a particular situation, have a particular finding, and that seems to apply to a section later on, that we can say we agree, or that's the
Correct.
same kind of thing?
And there's a jury verdict form that I'm going to give you that you'll go piece by piece.
Okay.
And if you have any questions, you can send the foreman back in to ask me the question.
an observer, not a juror, but you mentioned here it's desirable to have a unanimous decision. Is it required for an indictment of the grand jury or just a majority?
No, it's not required. Okay, and again, but I would prefer that it's unanimous. I would ask you to come to an agreement, and I'll poll you at the end to determine that. But we are not really technically bound by the rules of criminal procedure. Even Justice Scalia said that. Now we're trying to go as close to them as we can, but we're going to go by common sense. And even in a jury trial, there are many states that don't require a unanimous jury verdict. So some require a certain percentage or a majority or whatever. Many do require it, but we're not required to do that. And again, this is simply probable cause, a reasonable suspicion. The defendants will have an opportunity to defend themselves, and I think that would be a very good idea. We will certainly invite, if he's indicted, Special Counsel Mueller to come and to defend himself. If he doesn't, he'll be tried in any event, but he'll have that opportunity to come and defend himself. He can bring all of his partners from Wilmer Hale, including Jeannie Rhee and some others.
So after we render our decision at the end of the day, what's going to happen? Are you conducting the same type of trial in other locations, or this is the only?
Well, as I said, there are three phases. This is just to start a trial procedure. The legal threshold is very low. So if and when we get the indictment today, then we're going to set up a procedure to conduct a criminal trial, which will look a lot like what you see, in Law and Order or LA Law or whatever in the old days.
Okay.
We're going to give people an opportunity to come and defend themselves, and we're going to have a judge, and we're going to pick a jury, and we'll present the proof, and then we'll ask the jury to render a verdict, and then the judge will render a sentence if there's a conviction, and then we'll seek means to try to enforce the conviction. First, we'll ask President Trump to enforce it, and if he doesn't want to enforce it, we'll find a way peacefully and legally to attempt to enforce it ourselves. But whatever happens here, what's important is that we are educating the American people that we own this country. It's not the politicians in Washington, D.C., who, in my opinion, are too busy stuffing money into their own pockets and acquiring power than to represent the American people. And the judges on the court are so highly politicized that it's very difficult. It's going to be very difficult to even get convictions in certain places of this country where these judges, would throw the case out. They don't really care. There's a standard with these federal judges. If it's not plausible, that's the standard that they use. The Supreme Court put that in years ago. And of course, they're very political too. They're politicians in robes. Judge doesn't think it's plausible, he or she can throw it out. Well, they're sitting in the role of kings. We can get into that some other time. But that's why the people's justice is much more important. And that's, what our founding fathers intended. And that's why they created juries, because they did not trust King George III's judges. They were all in his hip pocket. And that's why we are telling the American people we need to rise up peacefully and legally and enforce the rule of law and our Constitution ourselves, as our founding fathers did in 1776, not by declaring war a violent war, which they didn't want to do either, they were forced into it, but through the tools that we have to try to mete out justice peacefully and legally. Because in my view, again, my views are not yours, but I'm telling you, the situation with Robert Mueller cannot be permitted to happen again. There must be accountability. Any other questions? Then we'll begin, and we'll see if I had Dr. Corsi scheduled for 2 p.m. Eastern Time. I'll see if he's available now.
Check with him.
We'll take a little break.